We all know that the United States judge decided that XRP did not break federal securities law by offering its XR for sale on open exchanges. This decision was a significant legal win for the cryptocurrency sector and caused XRP value to skyrocket. Data shows XRP had increased by 75. Although it also granted the SEC a partial victory, U.S. District Judge Analisa Torres' decision was the first victory for a cryptocurrency corporation in a case brought by the SEC. Despite being limited to the particular facts of the case, the ruling is expected to give other cryptocurrency companies fighting the SEC more leverage in their legal battle over whether or not the regulator has jurisdiction over their products. A representative for the SEC expressed the agency's satisfaction with a portion of the decision, which found that Ripple had broken federal securities law by offering XRP directly to knowledgeable buyers. If the judge permits it prior to the issuance of a final verdict, the decision may be appealed. According to an SEC spokesman, the judgment was being reviewed by the regulator. The decision was seen as a huge win for Ripple, but more importantly for the industry overall in the US by Ripple chief executive Brad Garlinghouse in an interview. The biggest cryptocurrency exchange in the US, Coinbase, said that it will once more permit XRP trading on its platform. We've read Judge Torres' well-considered ruling. We've gone over our analysis in detail. Paul Grewal, chief legal officer of Coinbase, tweeted time to relist on Thursday. Coinbase's shares finished at $107 per share, up 24. By selling XRP, which Ripple's creators founded in 2012, the company and its current and past chief executives were charged by the SEC of executing an unregistered security sale for $1.03 billion. The cryptocurrency sector has been keenly following the case, which refutes the SEC's claim that the great majority of cryptocurrency tokens are securities and so governed by its stringent investor protection regulations. Several of the agency's over 100 enforcement proceedings involving cryptocurrency, alleging that different tokens constitute securities, have resulted in settlement. Judges have agreed with the SEC in the few cases that have gone to court that the cryptocurrency assets in question were securities. Unlike strictly regulated assets like commodities, securities must be registered with the SEC by their issuer and require comprehensive disclosures to warn investors of potential risks. According to Torres, buyers of XRP that Ripple was selling on open cryptocurrency exchange had no legitimate expectation of profiting from the transaction, so the sales were not considered offers of securities. She described those transactions as blind bid-ask transactions in which purchasers could not have known if their payments of money went to Ripple or any other seller of XRP. An investment contract is a type of security that Torres used, according to a U.S. Supreme Court ruling that defined it as an investment of money in a common enterprise with profits to come solely from the efforts of others. According to Torres, XRP sales made on cryptocurrency platforms by Garlinghouse and Chris Larson, the co-founder and former CEO, as well as other distributions like staff compensation, did not constitute securities. Torres determined that the company's $728.09 million in XRP sales to hedge funds and other high-end purchasers amounted to unregistered securities sales, giving the SEC a partial victory. According to Torres, Ripple was pitching a speculative value proposition for XRP that hinged on business efforts to construct the blockchain infrastructure, supporting the digital asset. This was evident in the company's marketing materials targeted at institutional investors. According to her, a jury will have to determine if Garlinghouse and Larson helped the firm break the law, and defendants will not be allowed to claim during the trial that they were not given fair notice that XRP was a cryptocurrency. The law does not require the SEC to warn all potential violators on an individual or industry level. She stated, the decision, according to Kattenmuchin Rosenman attorney Gary, should support Coinbase in its legal battle with the SEC. He described the verdict as a tremendous event for the industry based on the reaction of the market. The main issues raised by the Coinbase and Ripple cases center on registration requirements and whether particular digital assets qualify as securities under U.S. law. The cryptocurrency sector has been calling for Congress to define the status of digital assets. And the verdict has prompted further calls for legislation that would provide clear guidelines for tokens. Republican Majority Whip in the House of Representatives, Tom Emmer, stated on Twitter that the decision proved that a token is separate and distinct from an investment contract it may or may not be part of. What is the CEO of Ripple's opinion on the chairman of the former SEC statement about XRP standing? Brad Garlinghouse, CEO of Ripple, has responded to in response to Jay Clayton, the former chair of the SEC, Brad Garlinghouse, the CEO of Ripple, expressed his thoughts on the current status of cryptocurrency regulation in the U.S., Clayton. The former chair of the SEC views the state of cryptocurrency regulation in the United States. At a recent gathering that the council sponsored regarding foreign relations, Clayton conveyed compassion for struggling cryptocurrency business owners obtaining funds. I have a lot of empathy for business owners who desire to solicit donations from the general population, and I have a lot of empathy for the retail investors desiring such kinds of chances. Dave Clayton, the previous chair of the SEC, pushed for favorable crypto laws to be established by us regulators. It might facilitate fundraising for cryptocurrency companies. Clayton argues that the proper approach to govern cryptocurrency is to acknowledge that digital technology, not things, is an asset. Moreover, the former head of the SEC noted that the argument over whether cryptocurrency asset belongs in the securities or commodities categories is exaggerated. Most of the judgments in whether a crypto is a commodity or security are rather simple, he said. Clayton's comments elicited responses from cryptocurrency fans, including Garlinghouse, as was to be expected. In response, the CEO of Ripple expressed his disbelief after hearing Clayton's fresh viewpoint on regulating cryptocurrencies. Apart from Garlinghouse, attorney Bill Morgan responded to Clayton's most recent remark as well. Attorney Morgan claims that Clayton was only interested in the securities discussion when it suited him, their ability to compete with Ethereum and Bitcoin. Attorney Morgan claimed that through his engagement, Clayton was identifying winners in the cryptocurrency field. In the contentious 2018 book Ethereum Free Pass Speech by William Hyman, it is important to note that Clayton oversaw the SEC when Hyman made the notorious speech stating that Bitcoin and Ethereum are not securities. After Hyman's contentious speech, Garlinghouse and David Schwartz of Ripple went to the SEC to obtain clarification regarding XRP. Garlinghouse stated that Ripple is living in purgatory as a result of Hyman's remarks. During that period, neither Hyman nor Clayton specifically considered XRP to be a security. Nevertheless, the SEC, led by Clayton, accused of selling XRP to Ripple as an unregistered securities. On December 22, 2020, Clayton's last day of employment, the SEC filed a lawsuit against Ripple. It's interesting to note that Ripple won partially because the court decided that the majority of transaction securities as claimed by the SEC do not exist. Additionally, the court decided that XRP is not a security. As the regulator purports, the legal dispute, which has persisted for over the 3-year period, is almost over. Interestingly, the lawsuit has moved into the remedies phase, which will establish the maximum fine Ripple is able to pay for selling institutional customers, XRP customers. Whether the summary judgment will be appealed by the SEC decision following the proceedings for remedies is still pending. Labs, the development team behind Zum, XRP, the creator of XRPL Labs, YSC Wind, that was revealed by the Zum development team in a recent X post. A screenshot of a page outlining how to order a Zum Tandem card was given by Wind.